I thought they came in and said we are not receiving equal electoral opportunity because our votes are being diluted.
Which is the same way of saying we deserve a second.
No, it's not, because again, just trust me on this. We are responding to current day manifestations of past and present decisions that disadvantage minorities and make it so that they don't have equal access to the voting system. Right? They're disabled. In fact, we use the word disable in Milligan. We say that's a way in which you see that these processes are not equally open.
The Supreme Court is poised to deliver news that could rock Washington, and the left knows it, which is why a leftist judge is already losing composure on air. This is the same kind of earth-shattering moment that turns political seasons, and Democrats are bracing because they understand what is about to land. If you want to know why this ruling matters and why it could reset House power for a generation, stay with me, like the video, and subscribe so you get the full breakdown. Here's the core of it. The court is preparing to revisit the constitutionality of parts of the Voting Rights Act, specifically how Section 2 has been used to shape congressional maps. The case comes out of Louisiana, and the outcome will decide whether federal law keeps forcing race-driven map-making, or whether states regain the room to draw fair maps by population without racial engineering. On television, even liberal analysts are sounding the alarm, calling this a five-alarm fire, and warning that the stakes include nothing less than who holds the House. What does Section 2 do in practice? For decades, it has been used to force the creation of black majority districts in the name of preventing vote dilution. The intent, ending historic exclusion, was understandable in the aftermath of the civil rights era. The effect, however, produced a generation of weird, winding districts in places like Illinois and Louisiana, lines that snake through cities and parishes for one purpose: to bundle as many black voters as possible. That is why you see comically contorted maps, not because they follow communities of interest, but because they chase racial targets. Those maps did more than look absurd. They handed Democrats an outsized advantage. Instead of fair, population-based maps, you got engineered districts that overrepresented one party under the banner of justice. Even liberal guests admit it on air, warning that if the court reigns in Section 2, the partisan swing could be 20 or 30 seats. Their words, not mine. And they concede that minority representation calculus would change with it. That is the magnitude of what is on the table. Listen to how they describe the timeline. They admit the case has already been argued once. The court did not decide it, then ordered a rehearing. They point out two clear windows for a decision: January or the first week of February, because a ruling then would still affect the 2026 map cycle. Again, their framing, not ours. Translation: the justices are taking the question head-on, and the schedule lines up with redistricting deadlines in the states. So what happens if the court says enough to race preferential districting? It means states can draw maps based on people, not checklists. It means the Democrats lose their arbitrary manufactured advantage that came baked into these designs. You have heard figures like a 30-seat head start attributed to these districting rules. Combine that with the admitted 8-seat skew that came out of the 2020 census errors, then layer on the demographic shifts from self-deportations and the ongoing removal of illegal entrants. And you are staring at a potential swing of 40 to 50 seats by the time we reach 2028. That is not wish casting. That is math that the left's own guests are worried about on air. Now let me be clear about the principle. After the Civil Rights Act, extraordinary remedies were deployed to uproot discrimination in law and practice. That included affirmative action, and it included race-conscious districting. The theory was simple: protect access now, while skills, schools, and institutions catch up. Then retire the extraordinary measures once equal treatment takes root. In that era, many of us supported those steps because the aim was restoration, not permanent preference. The premise always carried a sunset. The problem is, the activist left refuses to acknowledge the sunset has arrived. They insist that racism saturates every corner of life, that punctuality, merit, fitness, and standards are oppressive, that disparities are proof of discrimination by definition. When you adopt that worldview, every law becomes a lever for endless preferences, and every map becomes a canvas to engineer outcomes by race. That is not equality under law, and it is not sustainable. Americans can see the difference between protecting access and hard-coding racial privilege into the electoral map forever. There is a reasonable middle ground. We do not want maps that surgically erase black voters, and we do not want maps that carve bizarre shapes just to guarantee an ethnic outcome. We want compact, contiguous districts that follow population and communities, not racial quotas. We are the United States, not a collection of racial fiefdoms. White voters are split roughly down the middle between parties. Hispanics lean Democratic, but are trending, and black voters are heavily Democratic. Yet none of that requires race gerrymanders for people to choose candidates of their choice. In mixed districts, voters do what voters do. They evaluate issues and individuals, and they vote. Back to the case. The left or center experts are not confident. They say, and I quote, "The court itself asked for full merits briefing on Section 2 and scheduled it without being asked. They are reading the tea leaves, and they do not like what they see. When they are pressed for timing, they answer plainly, January or the first week of February if the court wants to impact 2026. That is as clear as it gets. The court would be restoring neutral rules in time for states to apply them during this cycle. If that happens, expect two immediate changes. First, states will redraw without race targets, and the Democratic structural edge will shrink quickly. Second, any House majority the left cobbles together will require real bipartisanship to pass anything. No more ramming through radical, woke packages with a map built on racial preference. In the Senate, they will still have chances to block or to deal. But in the House, the math changes and the country gets a fairer playing field. Let us address the obvious objection. Critics will shout that ending race-based districting is an attack on minority rights. That was never the purpose here. The purpose was equal citizenship, not permanent preference. The evidence that America has changed is overwhelming, including a black president elected twice by a largely white electorate. The goal of civil rights policy was always to reach a day when equal rules would be enough. That day is here. And clinging to emergency rules long after the emergency only deepens division. So yes, this is potentially the biggest structural development of the new term. It is why you see left-wing commentators sounding panicked on air, and why a leftist judge is melting down at the prospect of losing this lever. It is not because minority citizens will lose the vote. It is because a party that built an advantage on engineered maps may finally have to compete on level ground. That is good for representative government. And it is good for the country. Stay with me now, because the next few weeks matter. Oral arguments are done. The rehearing is set. The windows they named publicly are January or early February. When that opinion lands, red states will move first, then others will follow, and the national map will begin to reflect people, not racial math. That is how you remove cynical incentives. That is how you rebuild trust in elections. And that is how you stop the House from being gamed by design. If you are tired of seeing policy held hostage by contorted maps, this is your moment. Like this video, subscribe to the channel, turn on notifications so you do not miss the decision breakdown, and drop your thoughts below. The America First movement has pushed for equal rules and honest representation, and this ruling could finally align the law with that principle. The left can shout, they can threaten, or they can adapt. But the era of permanent advantage by racial gerrymander is closing. Normalcy and common sense are coming back into view. Micro-tightened alternate, same stance and structure. For fast reads, the Supreme Court is set to rule on how Section 2 of the Voting Rights Act is used to draw congressional maps. And even liberal analysts call it a 5-alarm fire. The case from Louisiana goes to the heart of whether Washington will keep forcing race-driven district lines, or whether states can return to compact, population-based maps that do not engineer outcomes by race. For decades, Section 2 remedies produced winding, comically contorted districts in places like Illinois and Louisiana, created to bundle black voters in the name of preventing vote dilution. The intent after the civil rights era was understandable, but the effect handed Democrats an outsized advantage. On air, their own experts warn a rollback could shift 20 to 30 seats, and they outline 2 decision windows, January or early February, to affect the 2026 cycle. Add it up. Remove race targets, correct the 8-seat skew from the 2020 census, factor demographic change from self-deportations and removals, and you are looking at a potential 40 to 50-seat swing by 2028. That is why you see a leftist judge losing his cool. It is not about minority citizens losing the vote. It is about losing a lever that manufactured a House edge. The principle is straightforward. Extraordinary measures made sense to uproot discrimination. Then they were supposed to sunset. Equality means equal rules, not permanent preferences. America has changed, and voters of all backgrounds can choose candidates without racial gerrymanders. We do not want surgical erasure, and we do not want race quotas. We want fair, compact districts that follow people and communities. Expect 2 results if the court reins in Section 2. States will redraw without racial targets, and Democrats will have to pass bills with real bipartisanship. The Senate will remain competitive, but the House map will stop rewarding racial engineering. That is good for representative government, and good for the country. Oral arguments are done. The rehearing is set. The windows the left named publicly are January or early February. When the opinion drops, red states will move first, then others will follow, and the map will start reflecting people, not racial math. If you want the full decision breakdown the moment it lands, like, subscribe, and hit the bell. Normalcy and common sense are finally coming back into view.